Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.
So, very interesting article, and the article basically talks about women's property rights, and if we the author basically talks about various concepts here. I'll briefly explain those concepts. The author suggests that there is no parity of rights. There is, and even if there is a legislative parity of rights, much needs to be done on the implementation part. And he says that the law of coparcenary was abolished way back in 2005 by the Hindu Succession Amendment Act 2005. But the message is just to percolate down. The message has not yet gone down, and people are still stuck in the patriarchal modes of thinking. And the women's right to property has not been materialized in the way envisaged by the parliament. Now, in the process of setting forth the arguments, they say that they touch upon several concepts. One is the concept of Mitakshara school. I'll just briefly touch upon that, and then they say that in the Mitakshara school, here it says Hindu inheritance laws, especially under the Mitakshara school, denied daughters proportionary rights in ancestral property, the privilege exclusively for male heirs. Now there can be a question in the question paper because this is a item appearing in the newspaper. Therefore, we are supposed to be aware of the same as to what was the Mitakshara school. There can be a question as a part of your legal awareness, and there can be another question with respect to what is the proportionary. What is this concept of proportionary? So let me briefly. These are the two concepts that I will touch upon. Otherwise, what is there in it is basically in sum and substance. Nobody can question the wisdom behind the things which are stated in the paragraph. The insights contained in the paragraph are age-old insights, which the kind of society that we want to see, or we want to see happen before us. Those things are stated here, and how that transformation can be brought about, basically by awareness, by sensitization, correcting the attitudes, or giving the correct inculcating the correct attitudes among the kids right from an early age, so that the patriarchal notions take the back seat. And what is envisaged in our constitution is the development of scientific temper. This is one of the duties, fundamental duties under our constitution, under Article 51A. The fundamental duties are contained, and one of the fundamental duties is to renounce practices derogatory to the dignity of women, and also to develop a scientific temperament. So this is our duty, to develop the scientific temperament and to renounce those practices. And sensitization, and better and better implementation, executive action, executive promotion, beti bachao, beti padhao. Those are the things basically that will eventually lead to a parity, gender parity, and by erosion of the patriarchal attitudes in our society. It is not going to come about in a day, but surely it is the direction in which the efforts should be ongoing. So, having said that, I will take you to the basics. The basics of this is contained here. The Mithakshara school, the Koparsanari rights. Now, the Mithakshara school is basically a school which is um, which is basically which originated from Vijnaneshwara. Vijnaneshwara uh, was the commentary which is written on the Yagnavalkya Samiti. I'll just share with you a document which will also give you the printed form of something on your screen so that you can relate to it while I'm speaking. Sometimes the context is broken. Therefore, to avoid that kind of thing, I just share that document also. I'm sure you'll be able to see on your screen what I'm trying to share. Is it uh, is it visible to you? What I'm
Yes,
showing on
sir.
the screen. It is visible. If it is of appropriate size, then it's okay. If it is requires to be a little bigger, and I can try for that. Um, since you're not giving any input, I presume that all of you can read it, right? Um, let me see if I can make it a little bigger. Has it become bigger now, or is it of the same size?
Sir, it's visible. That's matter.
It's visible. It is not become bigger, right? It is visible, but it has not become bigger, right? This is what you are saying.
Yes, sir.
All right, but it is visible. I mean, you can read it. All right, that is what is the entire objective behind it. Now, Mithakshara school was the school which was prevalent all over the country. What was it replaced with? It was replaced with the Hindu Succession Act in the 1956. Earlier, there used to be polygamy. That is to say, one person, like in Islam, used to have several wives. I mean, not everyone in Islam has several wives. Few people misuse those provisions and have those number of spouses. Not everybody does that. In the same way, in Hindu law also, this social evil used to be rampant. But this was taken care when the Hindu Marriage Act was enacted, and polygamy was abolished, and monogamy was established. Now, another important aspect of gender parity is that of property. Now, this is the Mitakshara school lays down that the property shall be uh, shall devolve according to the institution of co-partners. They are not co-partners. They are different. Co-partner is a slightly different term, different concept from the kind of co-partners in a partnership. It's not that. The peculiar feature of co-partnery system, as the article says, emphasizes the concept of co-partnery and meaning that ancestral property is owned jointly by all the male members of the family. Meaning thereby, only the male members in the family can be members of the co-partnery. Means female members are not a part of the co-partnery. Right. Now, the approach that we have taken towards understanding law, just a little digression from this I'm taking. You will read in your study materials, which I pointed out that you have to read these study materials. We take up articles for discussion. In those articles, whatever comes of importance of legal awareness, of whether of current awareness or whether of anything else, exemplifying the legal articles, the concepts which are, because what is in syllabus is what not what is given in a commentary or that commentary on this law or that law, whether it contract law, whether it is tortious liability, principles of tortious liability, whether it is constitutional law, whichever may be the law. Basically, those people are not looking for legal scholarship, but they are looking for your skills in terms of reading the printed text. And for a lawyer, the most important asset is his ability to do quick research, number one, ability to understand, ability to read quickly, ability to present his arguments effectively, and ability to write persuasively. So these are basic they are looking at. but they are looking at these terms for a well-educated person, well-educated student. They are not looking for a well-educated lawyer. That is what will happen when you go there. That is what they are going to teach. So these concepts which are in everyday use, which every educated person, aware person is expected to know, they will confine themselves to that. And I am limiting myself only to those concepts. I'm not getting into this book or that book, what this book says or that book says. There can be a shelf full of books on law, but they seem to be quite beside the point. What is on the point is what is appearing in the press, what kind of public discussion is taking place, informed public discussion, and what are the concepts, and they call it legal awareness. That is what is our approach. That is how I will not be teaching you what is written in the guide from A to G, but I'll cover more than what is written in the guide. But I will do it in an applied manner, and I'm sure you will agree with me. When I do it in an applied manner, the entire guide or whatever study material you have, the entire thing will come live to you. You will be able to draw linkages between what you are reading in your classes, in our interactions, and what papers you are attempting, and you will be able to draw linkages with what you will find in the study items I have marked and indicated. You will easily be able to draw linkages there. And if you are able to draw effective linkages, then I don't think the objectives of this interaction will not be met. If you can draw effective linkages between what is being discussed and what is in the printed material, then our objective is met. So having said that, I return to the topic and I say that this was a coparcenary system, was a genius of a system, but it was a very evil genius. Evil genius in the sense that it excluded very cleverly 50% of the humanity from property rights, and thereby made the entire human race predominantly patriarchal. Rights are the most valuable rights, are one of the most valuable rights in the society. And if you make the if you establish the uh, sole proprietorship over such rights of one gender, then it is bound to happen that another gender is going to lose the the sway, or the patriarchy will be able to gain a foothold. And misogynist means hatred for women attitudes will prosper. And that this genius of Hindu law, this Vijnaneshwara's commentary on of the 12th century's Yagnavalkya, is one of those systems which is basically at the root cause of this patriarchy. And it was very convenient for everyone to just ignore the property rights of women and focus on the property rights of males alone. And this is exactly what they do. This is the meaning of coparcenary basically. Means even if a child is in the womb, he becomes an inheritor of the property in the womb itself. But if the child, the gender of the child is female, then no such rights invest in here in such unborn child. But if the child happens to be a male, the rights will inherit even before the baby is born. So that was the system of coparcenary. Now, in the system of coparcenary, if one of the then that and he is not survived by any other brother, he is one of the brothers is died and he doesn't have any what we call as so if his wife is there and then others are there, now the joint property will go to the other surviving copartners, but nothing will come to the wife. So you can see how inequitous, that is unfair, this system can be. Suppose 5 brothers are there, one dies, and in that, or leaving behind a wife with 2 female issues, what happens of the rights of the daughter? She doesn't have any right, she becomes propertyless. So see how dangerous can be that system, this system. So what happens to the surviving wife? She becomes dependent on that family, she doesn't have any rights, there are no property rights. So this system can work very, very iniquitously against the females. So this is the system of coparcenary, and it used to be prevalent all over India except for 2 states, that is the state of Bengal and partly in the state of Kerala also, where matrilineal societies was the norm. Though this is so west, north, south, central India, this system of Mitakshara used to prevail. And what was the other system which used to prevail, which was not so cruel to women, and which at least recognized some of the inheritance rights of women? That is the system of Dayabhag, which was in existence in the in the in the Bengal and in Assam. They This was developed by Jimut Vahan in the 12th century, and basically now the difference between the two, as I have stated, is this thing. Then what happens? Come 2005, then 2005. Actually, even prior to 2005, there have been legislative developments wherein the apex court, by its progressive interpretation, and the legislature also through its 1956 Code of Succession, Hindu Succession Act 1956, has also, wherever it was possible, they have stated in Article Section 14 of the Hindu Succession Act. Let me pull out Section 14 of the Hindu Succession Act. What I am saying will become slightly clearer to you, because otherwise it would tend to be a little more what we call as a little more theoretical and a little difficult to understand. So if I just pull it out, it would become a little easy for you to understand what I'm talking about. So if you see the Hindu Succession Act, and Hindu Succession Act basically talks about yes, here it is, Section 14 of the Hindu Succession Act. This is what it is. Any property possessed by a female Hindu, whether acquired before or after the commencement, or shall be held by her as full honor thereof, not as limited honor. So you see what they are saying. Section 1956. This is revolutionary. They are saying if a property comes to a female, all right, then that property is going to be held by her. Suppose it comes in a limited form to her, then it will be held by her as if she is the absolute owner. So the limited property is being expanded by the law into full property. What is the meaning of that? What is the meaning of such a thing? Suppose a limited property is there in the female. Suppose a maintenance property has been given for maintenance of the female, or even if the husband is surviving, he has made a gift deed in favor of the female, that you will enjoy limited rights of enjoyment to the property. And he does not specify who is the reversioner, to whom the property will go after a demise. So the law says, where any property possessed by a female Hindu, after or before commencement, shall be held by her full honor, not as a limited honor. So once you have given the property, that will become a full honor. And so the limitation which you have put on that property will disappear the moment you have put in the gift deed. Do you follow? So a limited right which has been given, that you have a right of user in this property, that limited right will convert into full right by reference to Section 14. All right. That is, and the courts have also given very expensive interpretation of this, and they have recognized, sensitized the Supreme Court of India and the other courts have acted to use this article to expand the gamut of rights available to women. If they inherit limited property, they will make it into absolute and full property. So that kind of thing is already existing. This is the position earlier. Now what happens in 2005? Come 2005, they destroy the system of proportionality and make daughters the equal heirs. They say that the daughter is also a part of proportionality when it comes to an end. So that kind of the evil genius which was there since the 12th century was destroyed in the 20th century. 8 centuries of patriarchy. How will it disappear in just a few decades? How will it disappear? It can't disappear. It will take its own time. It will take its own set of injustices. It will take its own set of struggles to bring about parity. It's not going to come about merely by legislation. Legislation is important. Why it is important? Because you see, in the patriarchy was established by legislation in the 12th century when Yagneshwara gave his commentary on the Yagnavalkya Samriti. At that time it was established. Now it will go away also by legislation. So these kind of legislations are called leading laws. That means laws which are leading the social morality, leading the morality along a desired path. Those are leading laws. But if we look at technology laws that are coming up, for example, the law which is going to regulate artificial intelligence, there have been so many conferences, there have been so many statements, there have been so many models, the US model, the European Union model, the Indian model, so many models have been there on regulating the open AI, but we don't know what is the proper model as of now. Sometimes Europe tilts to the US, and sometimes US seems to tilt or seems to find its own systems inadequate. Now, this is called lag law, means law is lagging the development. What the Indian legislature has done is, in 2005, in the 21st century, they have done away with an institution which has been at the heart of the patriarchal system which has come into existence. And they have tried to establish an egalitarian society, which is one of the goals of our constitution. Justice, social, economic, and political. So social justice, they have tried to equalize. They have tried to institutionalize social justice. They have tried to look at the distributional aspect of justice, which is of John Rawls, of the philosopher John Rawls. So they have tried to achieve that constitutional parity, Article 14, that equality in the rights to property. They have tried to establish all that, right? So I thought I am sure you must be very clear on the 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 significance of what was done in the Mitakshara School of Law, and how the 2005 amendment has done away with what is the bedrock, which is at the foundation of the patriarchal attitudes, right? And now you will see that whenever property rights are, whenever legal rights are being contested, then all the heirs, including female heirs, they are whether married, unmarried, all of them are included these days, right? Now, but then I'll not get into that. That is different. So that is what is there. Now, having said that, I can take up the questions. I think the concept is clear to you. And if the concept is not clear, you are most welcome. And I will be more than happy to repeat. But and that is unlikely. Given your record of asking questions, that is very unlikely. Anyway, I come to question number 63. Which of the following is the author most likely to agree with? So two kids have marked it correct, one kid has marked it incorrect, so we take it up. It is saying most likely to agree with. Legal reforms alone are sufficient to ensure gender equality in inheritance rights. That's not what he's saying. He's saying many things are required. Equal inheritance rights for women will automatically eliminate patriarchy. Social reform must accompany legal reform. Of course, this is what he says. 2005 amendment is irrelevant. 2005 amendment has demolished or struck a fatal blow to the roots of patriarchy, and it's only a matter of time before the entire society gets a very different shape from what it is present. Just wait and watch, right? So now see what is question number 64 talking about. Two students have marked it correct, one incorrect. Based on author's arguments, which of the following, if true, would reduce the decline in value? Reduce the decline in value of reforms. So reduce the decline. Reduce the decline means which is going to promote women's inheritance rights. This is what he said. Daughters voluntarily giving up their rights. Poor creatures, they have been doing it all along. Now they should assert. For the last 8 centuries, they have been doing it. Now they should be asserting actually. Continued dominance of male heads in family decisions. No, heads are heads. Now that can be male or that can be female. It makes no difference. Widespread gender sensitization awareness programs. Yes, this is going to help. Increased migration marriage. That is neither here nor there. Chaliye aage. Now I come to the 65th, which is marked incorrect by 2 kids. Which of the following, if true, would most weaken the author's arguments? So weakening of the author's arguments. Women today are fully aware of their legal rights. This is one of the Curative steps that the author suggests is that we have to increase the awareness, you have to increase the sensitization, you have to rope in the NGOs, you have other components of our society and try to increase awareness. And he is just exactly, they are fully aware. The moment they are fully aware, then half of the battle is won. Male warriors now voluntarily share property with their sisters. Doesn't happen. Legal, this is what he says, that this is not what has happened. This has not happened so far in the 8 centuries. Legal amendment failed to abolish the doctrine of survivorship. So the doctrine of survivorship and the legal, that is exactly what it says. Proportionary doctrine is the doctrine of survivorship. Legal amendment failed to abolish. What is the doctrine of survivorship? That surviving male owners are going to get the property, right? So they have surviving male owners are going to. Now they have added it to it. They have added the female also to the law of survivorship. Whether you have to consider the females also, not marrying the male. You can't ignore the females and grant everything to the males. Now this is legal amendment failed to abolish. Now legal amendment has not abolished, but it has abolished. And what happens? Is it going to, if the legal amendment actually does not abolish, then it will weaken the author's argument or strengthen the author's argument? It is going to, I believe it is going to strengthen the author's argument instead of weaken the author's argument if it fails to abolish the doctrine of survivorship. He says, despite the abolition, the rights don't mean anything on the paper because it is going to take time and let us take steps so that the rights become real. They are not paper rights. The daughters still face threats and intimidation when claiming property, which is a reality, which the author also says. Author says that, so this strengthens the author argument. It actually doesn't weaken the author's argument. Then 66, I'm very happy, 100% correct, very nice. Then 67, no need to take. 68, no need to take. 60, then we have yet another TV rights. Yes, please come to this passage. Let us round it off. Round off this session by discussing this article. We have been sitting for 1.5 hours. Ideally, the sitting session should not go beyond 1 hour and 15 minutes. Let us finish it off. Let us finish it off by 4:15. Tell me what is written there. It's a very shallow article. There's nothing much in it.
So this passage talks about
Yes.
Pradhan Mantri TV Mukt Bharat Abhiyan, launched in 2018, allow the Nikshay Mitras to provide the nutrition support to TB patients.
Yes.
And the program faces serious ethical concern, particularly regarding the patient consent and the data privacy.
Yes.
TB patients must share the personal data to receive the nutrition support, making consent coercive rather than the voluntary.
Yes.
And the consent from lack clarity, failing to inform the patient that revoking the consent would not stop the nutritional aid. And the
Yes.
patients did not receive a copy of their consent, raising the concern about the data misuse.
Yes.
Uh, and the government officials, politician organization are among the big violators. And the scheme failed to ensure the universal nutrition support for TB patients. Uh, the nutrition is critical for TB recovery and India relies on charity instead of government funded support.
Yes.
The Tamil Nadu approaches are there. NGO hand over the nutrition kit to the district TB staff, uh, and the patients rarely meet donor, and the photography is strictly prohibited. And the differentiated TB care program uh, prioritize the undernourished TB patients for nutrition aid. And also, treatment support group provide the social and nutritional aid to ensure the treatment completions. And the TB should not be forced to share the personal data to receive the nutrition support. And the data and the government funded nutrition program should replace charity based model. And Tamil Nadu and the Kerala approaches prove that the patient confidently can be maintained, ensuring the effective support.
So this passage says that the Pradhan Mantri TB Mukt Bharat Abhiyan, uh, it allows donors to give nutrition kits to TB patients, and however, TB patients must give consent to share their personal data with these donors to receive the kits. And expert says that this consent is unethical and forceful because many TB patients are poor and they may feel forced to agree just to get food. And it also says that patient privacy is often violated as their photos are posted online without proper permission. And states like Tamil Nadu and Kerala have shown that it's possible to provide nutrition support without sharing patients' personal data. For example, in Tamil Nadu, donors give kits to TB staff who then distribute them without involving the patient directly. And Kerala gives financial help and nutrition kits to all TB patients through local government programs. And basically, this article questions why sharing patient data is necessary at all and calls for more ethical ways to support TB patients without compromising their rights. That's all from my side.
Yes.
So this article is a critique of the ethical concerns which surround the Pradhan Mantri TV Mukt Bharat Abhiyan, specifically the Nikishay Mitra program, where nutritionally deprived TB patients are coerced to to consent to share their data if they wish to receive additional nutrition. So the data is shared includes photographs of the patients, their physical statures, and other stuff that you measure. So now this is very coercive and ethically wrong since vulnerable patients are being coerced if they wish to receive nutrition to, to consent to share their private data, which violates the principle of voluntary consent, and that consent should be informed and voluntary, which is not the case here. There's also the violation of confidentiality since the data that is shared is not kept confidential and is widespread in both social media platforms and other government bodies, and it's also shared with private entities such as such as private hospitals and pharmaceutical companies.
Yes.
Undermines the dignity of the patients. So the article says that we must treat patient confidentiality as a non-negotiable ethical standard and must stop such coercive practices. It also takes the Tamil Nadu and Kerala model as a positive model, and we must learn from it, such as in the Tamil Nadu, the NGOs give kits to the district TV staff rather than directly giving it to patients, and the patients' identities are protected even when interaction is necessary, as photographs and other kinds of data sharing are banned.
Yes.
This does not compromise the privacy or dignity.
So basically, this very interesting article that highlights an ethical gap in the government-funded nutritional support program for TB patients. And the author basically comes out with the argument that some states are doing well, but most of the states are basically compromising the ethical standards and conducting themselves outside the realm of law. Because which law is violated? Contractual law is violated, and ethics and contractual ethics are violated. And so let us examine the facts. You people have already laid them threadbare that in lieu of nutritional support, they are sharing the data, and the data privacy is not kept. Data is splashed all over the internet and all over the social media, basically to score mileage, particular influence that the various political actors are taking these actions. So this the author describes as unethical, and he gives the examples of Tamil Nadu and the example of Kerala, which Kerala has gone all out, and they have stated that irrespective of whether or not you are eligible, you everybody is entitled for nutritional support. If you have TB, it will be presumed that you are entitled for TB to the state nutritional support. Technical gap should be mended, and it is not proper. Now, having read this article, now let us examine what is this concept of consent that they are talking about. Legally, the article proceeds. The entire article is devoted to the to the consent, to the data sharing, to the ethical part. Now, what is this consent? What is the concept of consent? What do you mean by consent? Let us examine this concept a little bit so that it becomes clearer to us. In the study material which I have asked you, advised you to is on contractual principles, and those principles are basically applicable here. When you talk about consent, let us see how those principles apply here in these fact situations when the state government goes ahead and discloses the data which it has collected. And the interesting part is the state government, the union government asks the beneficiaries uh, to give their consent, and if they don't want to, so what is the implication of this in legal terms? Whether this is a true consent, whether it is a false consent, what is so let us first examine a little bit on what is consent. If you come to section 13 of the Contract Act, right? If you have a look at section 13 of the Contract Act, please have a look at 13 of the Contract Act. You can see it on the screens, I am sure. Section 13 of the Contract Act says, two or more persons are said to consent when they agree upon the same thing in the same sense. So the consent is consensus ad ideam. People will agree on the same thing in the same sense. That is consent. That is what it says. Then it says, what is free consent? He says consent is free when it is not caused by coercion. What is coercion? It is defined in section 15, which says, I'll just refer to it. Coercion is the committing or threatening to commit any act forbidden by Indian Penal Code, or the unlawful detaining or threatening to detain any property to prejudice of any person whatsoever. So, what is the union government doing? Union government is telling them, you are free to enroll. You may not enroll also. But if you don't disclose, if you don't fill up this form, then you will be deemed to have not consented. So what is it that the government is doing? Are they applying coercion? Is it coercion? Coercion is the committing or threatening to commit any act forbidden by Indian Penal Code. So have they committed an act forbidden by the Indian Penal Code? The answer is no. The unlawful detaining or threatening to detain any property. Yes, this is there. If you don't fill up the form, then I am going to detain the property. And the detain the property is the property of nutritional support. So what the government is doing, if you don't consent, then I will detain this property. So this amounts to coercion. Therefore, this is coercive consent. What is the implication of coercive consent in terms of law? Please have a look. Consent says two persons are said to consent when there is absence of coercion. This is what they are saying. In the same sense, on the same subject matter, in the absence of coercion. Now, what is the implication? If there is coercion, that also we will come to understand. Here is the intention. Coercion is this, and the effect of coercion is stated in may not have been stated. This is here it is stated. When consent to an agreement is caused by coercion, fraud or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was so caused. Therefore, the party whose consent has been taken by employment of coercion or force or threat or duress, call it by whichever terminology you please. If that is, those elements are there, force, coercion, duress, threats, all those things are there, then in that case, the agreement is liable for setting aside. So what the person, the beneficiary of the nutritional program, what can he do? He can have the data disclosure page set aside. But the poor fellow is struggling with TB. How he will have it set aside? So some helpful stranger comes forward and writes this article in terms of the author that look, what you are doing is contrary to the law. It is not proper. What you are doing is by coercion, you are employing coercion and collecting another person's data, collecting another person's consent under coercion. Because if he doesn't give the consent, he will lose this property. And where is his entitlement to this property? Article 21 of the Constitution. Article 21 of the Constitution, for a moment, I will just refer to it. I will refresh your memory as to what is Article 21 of the Constitution talking about, of the Indian Constitution. What is it saying? You must be remembering it also very well. But still, I will just for once, for refreshing the memory, I'll refer to Article. The entitlement is contained in Article 21 of the Constitution, and Article 21 of the Constitution is here on your screen. It says, no person shall be deprived of his life or liberty except according to procedure prescribed by law. So the procedure has to be established by law, and the Maneka Gandhi case says this procedure has to be fair, just, and reasonable. That is to say, it establishes judicial review on whether or not the law which prescribes the procedure is a reasonable procedure, right? So I'm not getting into that. I will take you into that in a particular fact situation. At this time, if I take you into that, it will spoil the present context. So the entitlement of the patient, of the TB patient, to benefit from nutritional support program comes from two articles. One is the article, for no person shall be deprived of his life or personal liberty except according to procedure established by law. Now you'll ask me how it is a part of life. Nutritional support is a part of life. I don't have to argue the proposition, right? Now, the Supreme Court in Puttaswamy's case says that, look, right to life also includes the right to privacy. Therefore, right to privacy, though it is not specifically specified in our Constitution, nevertheless, it is a right which is derived from Article 21 of the Constitution. Right to life includes the right to privacy. Therefore, on two counts, you can say that the constitutional provision, which has been declared to be a fundamental right under the Constitution, under Article 21 in Puttaswamy and other bunch of cases which are talking about that. And of course, the right to life, because it is a matter of livelihood. It is a matter of nutritional support. So it is directly a matter of health. And health rights are also included in Article 21. So this is the procedure which deprives them. Now, the procedure is coercive procedure. Under the contract law, coercive procedure is a procedure which is unknown to the law. This is a procedure of which there any notice, and such law is liable for setting aside. Here, the law is the form which the TB patient is required to fill in order to gain access to nutritional support program of the government. Therefore, the same is liable to satisfy. I hope this is clear to you. Kids are not speaking as usual, so I presume that they know. Come to question 69. Which of the following, if true, would most weaken the author's argument? TB patients are always fully informed about the implications of sharing their data. Oh, weaken the author's argument. Then yes, if they are not aware, if they are fully aware, then there is no need of this article. They are not aware, then poor people and the government is taking advantage of all. Then what is it saying? Most TB patients report feeling coerced. They don't even know that they are being coerced. Mitras are not allowed to interact with patients under any. They are not allowed to take photos as per the author in the article. TB kits are sometimes delayed due to poor logistics. This is neither here nor there. So this is quite beside the point. Then this is based on author's argument. Which of the following, if true, would reduce the declining value of TB patient or patient confidentiality in TB nutrition program? Reduce the decline in value of patient confidentiality. So, which of the following, if true, would promote the patient confidentiality? That is the question. Two negatives make one positive. Therefore, which is going to promote the patient confidentiality? Patient confidentiality promotion has to take place. Nutrition support that will give rise to patient incentives that won't. If the moment you give the performance incentives, That means you are counting the beneficiaries. So that may not actually lead to patient confidentiality. That may erode the patient confidentiality further. Government mandates the donor-patient meetings for kit handovers. If that kind of thing takes place, these things should the donor should not come into contact with the recipient. Ideally, that is the situation. So this also does not. All photos of patients must be approved by government ethics panel. Why take photo in the first place? Forget about ethics panel. The ethics panel can take photographs of crores and crores of people, of beneficiaries. How it is possible in practice? Nutrition kits are handed over by TB staff without any donor interaction. That is the best. No donor interaction, no photos, no filling up forms. This thing, no filling up coercive forms, not required. Then there is 100%. So I need not bother. If authors' evaluations are the most important criteria in assessing TB nutrition programs, all right, then which of the following would be the most likely outcome based on the information provided in the passage? All right. Kerala program would be seen as the best practice model, of course. No doubt. Nikshay Mitra program platform would be scaled up nationally. Nationally. No. Kerala model should be scaled up nationally. Then patient consent would be made optional in all states. This is if patient consent, most important criteria in assessing TB nutrition programs, and which of the following would be most likely outcome? If you talk about, this is also correct, patient consent would be made optional. You may give your consent, you may not give your consent, you may give your data, you may not give your data, it doesn't matter. That kind of thing, which is akin to the Kerala model. Photographing patients would be encouraged. No, they should be discouraged. So, and revisit the video. You can look up those articles which I have touched and see in your study materials what treatment has been given to your articles. What are the articles we have talked about? We have talked about Article 19. There is a full section on constitutional rights in your study material. You can refer to that, right? Then we have talked about contractual provisions. I will just forward this write-up which I had downloaded from the internet. This Dayabhag and Mitakshara and all that. You can, in a summary form, you can remember all that. Or better still, I'll work it into some logical reasoning question in the Google form itself, so that you don't have several pieces of information flowing here and there. Instead of that, your centralized form becomes the repository of information, so that when you come to revise the things, it becomes handy for you. It becomes easy to control one document instead of looking at several other documents. The benefit of putting all this in Google form will be the context is ready and readily available to you. Don't have to think about the context. Women's property rights. So those kind of problems will be obviated. So it may not be directly relevant to some of the things, but then this is the foundation. Mitakshara's 12th century Mitakshara law, which was implemented all over the country, and how it brought about the inequity and distributional injustice that we are looking at in our society in the 21st century, right? So having said that, kids, we will meet tomorrow. Unfortunately, Pukhras sir was on leave today, so your class could not happen. And unfortunately, we could not contact him for the 12 questions which he was supposed to give for the yesterday's class. But I'll make sure that he gives you those 12 questions on yesterday's class. And if you have any queries, you are most welcome. Otherwise, we are done with the session. Seeing a record of interaction, there doesn't seem to be much scope for queries. So I'll close the session. All right.